if you don't comply with either federal or state securities laws, then bad things could happen. We'll get into that. So question number one, is my token a security? So back when I was in law school about 100 years ago, I remember reading this arcane case called Howey, and it had to do with somebody syndicating orange groves, interest in orange groves, right? That was Howey. And the court ruled, the Supreme Court of the United States ruled that, well, you know what? That is an investment contract, that interest in the orange grove, and that makes this a security and subject to securities regulation. So that's the Howey test. Something that I did not expect I would ever have to deal with again in my career, because how difficult can it be to determine whether something is a security? I mean, people are not usually trying to be cagey about that. Well, fast forward to today, and everybody is a securities law expert. Everybody knows about Howey, and everybody thinks they've got ways around it. But I would say not so fast. For example, Jay Clayton, our SEC chairman, has said that he's really not seen very many tokens, not seen any tokens yet that are not securities. He has, however, said that digital tokens are securities, such as Bitcoin, and there are tokens to finance projects. And he has recently said that a token could go from being a security to not being a security, but the SEC has taken a position that these tokens should be regulated as securities. Now, what is it that makes it a security? And we're going to get into that in a minute, but let's talk about the SEC for a second. So the SEC is all over this issue. They are warning investors about potential scams. They're very concerned about know your customer, for example, laws, anti-money laundering laws, and in particular fraudulent scams that seem to be really easy to do over the internet with ICOs, because fraudsters can use the lure of a new technology and a good story to convince people to put their money into something that doesn't exist. Another type of fraud is pump and dump. You talk it up and then you sell the tokens into the market, you cash out, and you abandon the project. There are many other types of market manipulation schemes, front running, all sorts of things. The SEC has suspended trading of companies that are involved in these, especially if there's not good information about the company, if there's questions about accuracy about the information, if the company's putting out false information through press releases and reports, or if there's questions about trading in the stock, trading by insiders, manipulation, etc. Some very kind of high-profile SEC actions. The Dow token was probably the first one we all heard about. That one was pretty obvious. They say that bad facts make bad law, and those were bad facts. They marketed that thing as a security, said it's just like buying shares in the company, even though the Dow was not a company at all. It was really just existed in code, but it was very much an investment contract. I don't think you could have concluded otherwise. Munchie was a little closer. This is a security, or this is a token that had real utility, did restaurant meal reviews, but the SEC halted that sale, halted those token sales through a cease and desist on the grounds that those were unregistered securities. Why? Because it targeted investors who had an expectation of future profits rather than the users of the products who were going to use the proceeds, who were going to use the token. It was for people who were investing in it. And the company itself, they were using the proceeds to actually develop their application. That sounds a lot like a security or an investment contract. You're pooling your funds to build a future ecosystem. And then finally, the marketing materials are pretty clear that people were going to get appreciation in the token itself. And let's pause on that for a minute. It's really interesting. This is one of those areas of the law where the classification of the instrument is going to depend on what's going on inside the head of the recipient. It's going to depend on whether the person who bought the token is doing it with an investment intent. Really interesting. So the SEC is not your biggest problem as long as you're being honest and you're not committing fraud and you're complying with know your customer and anti-money laundering laws. I think your biggest problem is Rule 10b-5, which is the private right of action. This gives private litigants the right to sue companies for violation of the securities laws and a right to rescission. If you just do a Google search, you'll see that many companies are being sued under this 10b-5 securities law violation. So in terms of compliance, now that we know that what we have probably is a security, how do we comply with these rules? Well, a public offering is generally evidenced by an S1 registration. I've not seen or heard of anybody doing a S1 for a token. Somebody probably has out there, but I think it would be extremely difficult because the public offering ecosystem is set up for stocks and securities. It's not really set up for digital assets. It'd be awfully hard to find a bank that would support you on this. There are securities law exemptions. Reg CF, Reg D, Reg A, Reg A+, Reg S. You've probably heard all of these alphabet letters before. We'll talk about those. Those have all been used or proposed to be used for the sale of tokens. And then thirdly, there is crowdfunding. That's Reg CF crowdfunding. So, which is being used very commonly for people to raise up to about $1 million in 12 months to go ahead and build out the application and then use a different exemption to raise more money.